Imagine asking an average person what happens inside a law school. The image that comes to mind is almost always the same. Students surrounded by massive stacks of dusty books, like this wall of old reports, reading intently to memorize thousands of static, historical cases. But learning the law by just memorizing things that are already out there is a complete misread of the profession. The legal landscape is actually a continuously updating network of concepts. There is a core flaw in treating a student like a human encyclopedia. The law is always changing. If you only learn a set of dry rules today, that knowledge base will be outdated by your 5th year in practice. A static memory cannot keep pace with the reality of legal practice, where statutes are amended, new precedents are set, and entirely new technologies emerge daily. Legal education provides the ability to know what to look for, where to find it, and exactly how to process and interpret entirely new information. Let me put this tangibly. If you call up a lawyer with a complex question, and without pausing she gives you a straightforward, simple answer, you should fire her. That rapid certainty indicates she is relying on immediate recall rather than engaging in systemic, analytical reasoning. Thinking like a lawyer is an active disposition centered around asking questions, analyzing choices, and calculating risk, rather than reciting simple answers. The goal is to develop a collection of adaptable cognitive tools used to deconstruct any novel problem you encounter, or at the very least, to identify exactly where to find the missing component. This adaptable mindset relies on a standardized 5-step cognitive algorithm designed to process messy reality and output strategic advice. Mastering this specific 5-step pipeline is the primary barrier separating a layperson from an effective legal strategist. Every legal scenario begins in the same place: chaotic, unstructured, and noisy real-world events. This brings us to step 1, digest the facts. Think of it as a rigorous data ingestion protocol where we gather raw, conflicting input. The lawyer must then organize these disparate inputs into a coherent, objective timeline, avoiding premature judgment about the case's merits. Once the data is ordered, we move to step 2, spot the relevant issues. Issue spotting is a vital filtering mechanism. It discards the emotional noise of the narrative to isolate the exact points of structural, legal conflict. Failing here results in a catastrophic error. You can execute a mathematically perfect legal analysis, but if you missed the core issue, you have solved the completely wrong problem. In practice, identifying the correct question hidden within the facts is often more difficult than finding the answer. Executing these first 2 steps, ingestion and filtering, is how lawyers bring structural clarity to a client's crisis. With the specific issues isolated, we reach step 3, determine the governing law. We transition from the facts of the case to the rules of the system. Look at these volumes of the U.S. Code. They represent the massive, searchable database of historical statutes and constitutional precedents that govern the system. While memorization isn't the end goal, hard content knowledge is required. The analytical engine cannot run without this fuel. Take a technical example from civil procedure. Understanding how specific claims that lack subject matter jurisdiction can be heard in federal court. You need to know the specific mechanism of joining these claims through 28 U.S.C. 1367. Citing codes like 1367 sounds intimidating to outsiders, but through training it becomes basic, retrievable knowledge at the tip of your brain. Knowing a specific statute is simply a tool retrieved from the shelf, ready to be loaded into the computational phase of the pipeline. That brings us to step 4, apply the governing law to the facts. This is the primary computational phase of the legal mind. The goal is to generate structurally sound arguments. Merging specific facts with relevant law generates divergent strategic paths, rather than a simple yes or no. The lawyer must then calculate and assign a probabilistic likelihood of success to each distinct argument. The ultimate stress test of this computational framework happens when we encounter scenarios that possess zero historical precedent. This algorithm's utility is measured by its ability to process legal issues that did not even exist when a lawyer was sitting in a classroom. Consider this image of a laboratory handling early embryos. It highlights a cutting-edge domain, the complex, novel legal rights surrounding in vitro fertilization. Or consider the legal questions of posthumous conception and inheritance rights for children born after a parent's death. There are no 19th century cases covering artificial reproductive technology. Instead, the lawyer uses the Step 4 framework to overlay established legal logic onto these brand new technological domains. Step 4 is the engine that applies established historical rules to novel, emerging problems. Finally, we reach the fifth and final node of the pipeline: align with the client's goals. An objective, probabilistic analysis must be mapped against what the client actually wants to achieve. This requires a translation process, converting probability calculations into an actionable, real-world strategy that protects the client's interests. However, there is a critical boundary. Serving the client does not mean abandoning your own agency as a professional. A lawyer is valued for the ability to exercise independent judgment on questions of law and policy. This sometimes means advising the client against taking an action, even if it is legally permissible. Step 5 is the bridge where abstract legal theory makes contact with tangible, human consequences. This 5-step cognitive framework is domain agnostic. It works across every sector of the profession. Look at this historical courtroom scene. The path of the traditional trial lawyer is just one way this algorithm is deployed. Public service advocates rely on this exact same framework to figure out legal strategies for cause lawyering, searching for the right client to bring a case. Corporate dealmakers use the same pipeline to design robust business structures and draft contracts that account for future risk. In any of these fields, lawyers will disagree on specific outcomes, but this framework ensures they argue using shared, persuasive logic rather than emotion. A legal education builds a resilient, analytical engine designed to process the complex legal questions of the future.